Good evening. It's May 6th. I am Liz Krueger, State Senator for the 28th District here in Manhattan. Tonight's discussion is going to be about managing debt. I want to welcome the participants who are viewing us on Zoom and Facebook, or maybe calling into the town hall discussion this evening. Remember, if you're calling in by phone, this is not interactive and you need to keep yourself muted. If you're on Zoom or Facebook, you have a closed captioning option. So as a viewer, you have to activate the closed captioning to view the text on your device. If you're on Zoom, click on live transcript in the meeting controls to start the viewing closed captioning. If you're on Facebook Live, you'll see a setting button in the bottom right-hand corner of the video. Click closed caption, CC, to start viewing with closed captioning option on. We have found many people find this very helpful, even if they are hearing okay, but not great. And many of us start to lose our hearing at the ages where we need it more than ever. So before we begin tonight's topic, I have some important reminders. It's just over a month. On June 22nd, there will be a primary election for many important New York City government offices. You'll have a chance to vote for the mayor, the controller, the Manhattan DA, borough president, um, and city council races. You must be registered in either the Democratic or Republican Party to vote in the primary election. You have until May 28th to register in a particular party. So it's not just are you registered, but if you want to participate in the primaries, you need to be registered for one of the two parties that have primaries, Democratic and Republican. Primary day voting will take place on June 22nd, but there will also be early voting here between June 12th through the 20th. You can request an absentee ballot as a third alternative. The deadline for this is June 15th, but I urge you to make the request sooner than that because things get slowed down, things end up late, and you want to make sure your ballot's counted. But remember, we now have 3 ways to vote. We can vote by mail through requesting an absentee ballot. We can vote early over a 10-day period, or we can vote on election day. Finally, you will find information on all this as well as information on ranked choice voting posted on the Board of Elections website, posted in our chat. Remember, we've already had a town hall on ranked choice voting, and you can go back and watch it if you missed it. It's online. It's online on my website. There's quite a few groups now hosting these kinds of webinars around ranked choice voting. So you might try somebody else's so you feel like you're getting the hang of this. All right, we never don't talk about COVID because this is New York and America in 21st century, and that's what we do. So regarding COVID, if there are any 16 or 17-year-olds in your family who have not been vaccinated and they're eligible, now is a great time for them to make an appointment or go to a walk-in vaccine site and get vaccinated. Remember, 16 and 17-year-olds need to get the Pfizer vaccine. The governor announced this week that the capacity restrictions are going to be further relaxed or removed this month in offices, retail shops, personal service shops, stadiums, performing arts, and gatherings. I woke up to hear that Broadway is reopening on September 1st. It definitely gave my heart a lift. Social distancing and wearing a mask continues to be required and are important safety measures when you are around larger groups of people in outdoor settings and when you participate in indoor activities, whether you are vaccinated or unvaccinated. The CDC has updated its guidance, which provides helpful guidelines for assessing safety risks and when to wear a mask. And now we will move to tonight's actual discussion, managing debt. You should know the event is being recorded. Everyone who RSVP'd for tonight's event will receive an email link to the video shortly. And it will also be including a fairly hefty list of reference points on sources and information. So don't think you have to write everything down because they will be made available to you by internet. And for those of you who are phoning in or might get confused about that, we can also send it out to you if you have trouble getting access to it by computer. All right, the overview of our event. I know that many of you are dealing with significant financial stress related to debt. You are not alone. That's the most important thing to understand. If you're actually going to be in debt in this country at this time, this is sort of when everyone is facing this. And we're trying to make sure that you know that there are some options and some things you want to avoid doing. Because when you're at debt and you're feeling vulnerable and you're feeling at risk, you may also find yourself falling for some kinds of scam artists that in other times you never would imagine yourself falling for this. So we don't want you to walk into worse situations for yourself because you are facing debt and stress and somebody comes along and promises you a silver bullet. There aren't so many silver bullets, but there are ways to address these issues correctly and incorrectly. Obviously, we know that the ability to pay rent, utilities, medical bills, and credit card bills have become much harder during times when people may have been laid off temporarily or permanently from the jobs that they had. And even though the federal government and the state are trying to come up with as many resources to fill those holes as possible, we certainly understand that this is the time that debt is building up. We're going to be discussing options with respect to debt and debt collection. You're going to get information on what to do if a collection agency contacts you and what options you have regarding rent arrears. Hopefully, most of you will come away with helpful direct actions you can take. I'm extremely pleased to introduce our experts tonight. Two of them I've known, I feel, for like ever. Ellen Davidson, staff attorney in the Civil Practice Division at the Legal Aid Society and housing lawyer extraordinaire, and Sarah Ludwig, the founder and co-director of the New Economy Project. And with Sarah, we also have Raquel Villagra, who works with Sarah and is a staff attorney at the New Economy Project. So I couldn't have three better people to be presenting tonight. Our speakers will offer information. First, Ellen, about Eviction Moratorium, which has been extended to August 31st, and rent relief funding. All right, there will also be information about predatory lending, a term I didn't know about 10 years ago, and now it seems to be ubiquitous throughout our economy, unfortunately, and what your rights and responsibilities are regarding debts you may find yourself owing. So my first speaker will be Ellen Davidson to talk about the housing side of the issues. Hi, Ellen.
Hi, Senator. Thank you so much for having me. Thank you to everyone who's here to listen. I'm Ellen Davidson. I'm a staff attorney at the Legal Aid Society. And I wanted to start the conversation by setting up what the various laws that currently have been passed by our legislature that affect tenants, what they are and how they work. Let's see, I have done a bit of a PowerPoint because we're talking about a bunch of different laws. I thought it might be easy to actually see them and sort of start to understand how they work together. And so the first one, and the first one, which has a lot to do with rent debt, in fact, is a law that's called the Tenant Safe Harbor Act that was passed last May. Now, for some of you who may have ever been in housing court, or even for those who've never been in housing court, what you should understand is that when your landlord sues you for non-payment of rent, your landlord is seeking a possessory judgment. And what that means is if your landlord gets a possessory judgment and you can't pay the rent, that at the end of that, your landlord can take possession of your apartment and evict you. In addition, and sadly, that even after you've been evicted, your landlord can continue to seek the money that he has gotten a judgment for. He can take you to small claims court and go seek to get a monetary judgment. Failing to pay monetary judgments can lead to things like attaching bank accounts and garnishing of wages. What the Tenant Safe Harbor Act did was it said that if a tenant could show a COVID-related financial hardship, that the tenant could not get a possessory judgment for the time period that there are COVID restrictions on a locality. And so how would you show that you had a COVID-related financial hardship? The courts are supposed to consider what your pre-COVID income was, what your COVID income was, your liquid assets, and then to look at whether or not the tenant or the occupant of the apartment is eligible for government benefits, which include things like unemployment or public assistance. So were you eligible for public assistance? Did you apply for public assistance? The time period that the rent that is owed becomes rent debt as opposed to something you can be evicted for is from March 7th, 2020 until all of the restrictions and the executive orders are lifted. So what does that mean? I actually don't know. I also heard the governor say that he was lifting all restrictions in New York City on May 19th. But I'm also hearing that there are still restrictions on Yankee Stadium and Mets Stadium. So I think at the moment, the Tenant Safe Harbor Act period is still in effect, but we'll figure that out as we go along. And what the time period means is during this time, if you have rent that is due, your landlord can sue, you owe the rent, but he can't evict you for not paying the rent. He can only seek a monetary judgment. And having debt has terrible consequences that we're going to talk about in the next section. But I think the legislature thought that keeping people in their homes during this time period was of paramount importance. Additionally, you may have heard, in fact, you just heard Senator Krueger talking about how the eviction moratorium, a law that stops people from actually being evicted, has been extended to August 31st of this year. Our moratorium law is not a complete moratorium. In order to come under the protections of this law, you must file a hardship declaration. And there are links that will be given on how for people to get access to the hardship declaration. If it seems like when we go through it, it is something that is true to you, that these are accurate statements for you. In the hardship declaration, tenants or occupants of apartments have to check either A or B. A has to do with financial hardship. And you have to say, I have a financial hardship. I'm unable to pay my rent or other financial obligations under the lease, or I can't find other suitable permanent housing because I've had a loss in income, significant increases in expenses. I haven't been able to work because I've had to take care of sick relatives. The declaration itself has a number of different examples. You only have to check that you've had a financial hardship, but it gives, if you read the declaration, you can see there are many different ways that someone could have a financial hardship. And then there's B. And B acknowledges that you may be someone who's paid your rent all along. Maybe you have had no financial hardship. But moving under these circumstances could be incredibly dangerous to you or someone in your household. Perhaps you're someone who is immunocompromised, or you have someone who's elderly or with a disability that makes you more likely to get COVID than the general population. And if that is the case for someone, then they check B. So under the moratorium, the money's still owed, but the hardship declaration, which can be either given to your landlord or to the courts, stops the case completely until August 31st. And if a tenant submits the hardship declaration, it is presumed that you fall within the first law that we talked about, the Tenant Safe Harbor Act. There's one exception to the moratorium, which is even for tenants who submit a hardship declaration. If the landlord's claiming that you're creating a nuisance, that you are threatening the safety or health of your neighbors, the case will still go forward. And these are the links. They will be given to you as well, but these are 4 different ways to get a hold of the hardship declaration, and each link will explain to you how to make sure it's properly filed. And then the last law that you should know about is the COVID-19 Emergency Rental Assistance Program that was passed as part of the budget. The first thing I have to say is this program is not yet open. We think it's going to be open in May, but if you've been searching on how to apply for the rent arrears money and can't find it, you're not alone. The information is not out there yet. The program will be run by the New York State Office of Temporary and Disability Assistance. We expect they will have information as soon as there is information online on their website. This will create an online portal for applications. Sorry. There it is. So how do you qualify for this program? A tenant or an occupant must show that you're obligated to pay rent, that your household includes an individual who qualified for unemployment or had a decrease in income or significant increase in expenses. You have to demonstrate a risk of homelessness or housing instability. And let me just tell you that if you owe rent, you are at risk of homelessness. And your household income must be at or below 80% of area median income. So what is 80% of area median income? In New York City, it means for a household of 1 that your income is less than $880,000. And this chart shows exactly what that is for households of up until 6 people in a household. And the question is what is your income now? You either have to show what your income was. Let's say that you had a period of unemployment and a period of income loss, but right now you're back to normal. You can still qualify for the program because it either asks you to show your income for this month that you've applied or the month you've applied, or your income for 2020. And as long as you are income eligible for either one of those, you will be eligible for the program. So when you apply for the application, when you apply, any eviction case gets stayed. So even if you apply in September and there's no eviction moratorium, you will not be evicted while you're applying for this money. You can get up to 12 months of back rent and up to 3 months of future rent. And for future rent, tenants have to show that they're paying more than 30% of their income toward their rent. There is no discrimination based on immigration status. And if a tenant doesn't have documentation of the various eligibility criteria, a tenant can submit an attestation saying, I don't have documents, but I lost income, or I don't have documents, but I am under 80% of area median income, if let's say you don't have income at all. So we think this program is going to be open, as I said, in May. New York City is going to be working with non-for-profits across the city to help tenants apply for it. So if you are someone who wants to apply, but thinks that an online application will be difficult, you will be able to be matched with a non-for-profit who will help you apply for the program. And hopefully that will end your rent debt. And so that's my presentation. I'm hoping if there are questions, we can go toward the end, but I'm going to pass it along to my colleagues.
You're on mute, Senator.
Off mute, everyone. Hi. Thank you very much, Ellen. I really appreciate your presentation. And yes, I forgot to mention earlier, there will definitely be a Q&A section at the end after Sarah and Raquel present on other kinds of debt management issues. So I will give it to them. I also want to just remind everyone, while they are here as experts, their organization does not take on individual clients with debt problems, but there are many resources that we'll be providing you in the resource list, growing on chat, and that will be available online to you, where you can learn where you might go for individual help with debt issues. So now I hand it over to Sarah and Raquel from New Economy Project. Hi.
Hello, good evening. Thank you so much, Senator Krueger. We really appreciate being part of your amazing town hall series. And Raquel and I are from New Economy Project, which is a New York City-based organization founded 26 years ago. I can't even count. It's been that long. Founded in 1995 to work with community groups in New York City to build a just economy that works for all, that's rooted in racial and gender justice, cooperation, neighborhood equity, and ecological sustainability. And so we have, since 2005, operated the New York City Financial Justice Hotline. So just to clarify one thing that's come up about our work, we definitely work with individual New Yorkers. In fact, we work with thousands of individual New Yorkers every year. What we don't do is debt counseling. So we just want to be very clear that we have a legal program that helps low-income New Yorkers who are dealing with a very wide range of financial justice issues. And what we wanted to talk to your constituents about tonight at this town hall is the aspect of debt management that we hear the most about, which is debt collection. So we've operated this legal assistance, this free hotline, as I said, since 2005. And we have worked with thousands and thousands of New York City residents who are being hounded by debt collectors. And let me just say that when we set up this hotline, we did not expect this to be the biggest issue that we get calls about. And yet year in, year out, year in, year out, we get far and away the most calls at the top of the list every year is abusive debt collection. And so we do know that there's been just this explosion in consumer debt over the last 15, 20 years with credit cards, student loan debt, medical debt. And it is really an economic justice issue. It's a gender justice issue. It's a racial justice issue. And it's something that so many New Yorkers are dealing with every single day of their lives, because there are hundreds, and there's no hyperbole here, this is not exaggeration, there are hundreds of thousands of lawsuits that are filed against New Yorkers in civil courts every year by debt collectors and debt buyers. And I'll tell you what debt buyers are in a second. And then also in our daily lives, so many people are getting hounded, getting harassed by debt collectors. If you've ever been on the receiving end of a call from a debt collector, and some people are getting them all day long, then you know that it is very stressful. It is nasty. It can be really scary as well. And so we've been tracking this industry for a long time, at the same time that we've been helping thousands of New Yorkers deal with debt collection. And we really want to convey a few things tonight. And one is that we all have rights. And that's one thing. There's so much confusion around debt collection, around credit reporting, and it really serves these industries very well that many of us don't fully understand, our rights or even know that we have rights. So we want to outline some of that. And you know, a lot of times what happens, and we're going to, you know, answer questions to make sure that we're addressing issues that you might be facing. But a lot of times what happens is we get phone calls on our hotline from New York City residents who don't even know that a debt collector has been coming after them until they find that their bank account has been frozen or their wages have been garnished. A lot of times these are older New Yorkers, but not exclusively, who call us and they find, including during this pandemic, that they can't pay their rent, they can't buy medicine or food because their bank account's been frozen, because they've been sued. And Raquel is going to tell us a little bit about what these lawsuits look like and what our rights are. But this is a very, very profound problem that is affecting so many people right now. And, you know, we have continued through the pandemic to see, you know, the courts sort of closed for a while, but these lawsuits continue and people continue to be hounded, oftentimes by these predatory debt collectors. And I said I was going to let you know what debt buyers were. There's been this explosion in credit and so many people turning to credit cards to cover basic necessities. The just massive unemployment that has, you know, hit New York on top of already existing job struggles that people have in unemployment through this pandemic. All the job loss means a lot of people have been, again, turning to credit for basic necessities. Tremendous amounts of medical debt from people who are not, you know, insured or not enough insured, and the cost of all the medical care that people have had. Well, there's a whole, you know, it's billions and billions of dollars of debt. There's an industry that's emerged in the last, again, 15 years or so that specializes in buying up this debt, buying up the debt that the credit card companies, the banks charge off. And they buy it for really cheap. It's just cost them, for every dollar of debt they buy, it costs them a few cents. So it's pennies on the dollar. They buy up this debt really cheaply. And then they really don't even buy the debt. They just buy spreadsheets with your name on it, with the names on it of people who allegedly owe this debt. And then they go after people in the courts. They don't tell them they're suing them. And this has been a tremendously devastating cycle for so many people and so many communities throughout our city and throughout our state. So we want to make sure that you get information before your accounts might go to collection, but we also want to let you know your rights. And it's no exaggeration to say that this is absolutely a pervasive problem in the debt buying industry, which is just notorious. I mean, for us, it is just, you know, it's all about, there's just pervasive fraud, deceptive practices, and all sorts of other bad things going on. So, you should be getting the sense that this is an extractive industry that is really taking advantage of people, particularly who might or might not owe the debts. And so being on top of all of this is one of the things we're going to talk to you about. So Raquel Villagra is a staff attorney at New Economy Project, and she is going to talk to you about some of the things that we see every single day on our hotline. And really, we want to make sure that you understand that this is for you to see if this is something happening to you or to prevent it from happening. And through the experiences that we have, get a sense of your rights, what resources are out there, because there are a lot of great resources in New York City for you that are free and excellent. And then we're going to take a slightly different approach, which is to kind of cast this in a true or false quiz. So get ready to share, you know, whether you think something that she raises is true or false. Again, it is so much bad information out there. We want to make sure you have the right information so that you can act on it and that it's useful to you. So I'll pass it over to Raquel. And thank you again, Senator Krueger. We love working with you.
Yes, thank you, Sarah. Thank you, Senator Krueger. So as Sarah mentioned, I'm going to dive into some of the things that she was touching on. But before I get started, I wanted to underline that there are, I think, two key takeaways that I hope everyone walks away from this town hall on our piece on debt collection to have really gotten. The first key thing is I'm going to talk about the main stages of debt collection that we see through our hotline, and maybe they'll be familiar to you, maybe not so much, but we see debt collection in three main stages. And I want to underline that you have rights at every one of those stages. So when I describe the kinds of things that we see. And if that sounds familiar, I just want to drive home that there are rights at those stages, and you are able to assert them. And we hope to give you some of the background knowledge today to empower you to know that and assert those rights. And the second takeaway is, again, underlining something Sarah mentioned already, which is that the debt collection industry is rife with abusive practices, discriminatory practices. They extract billions of dollars from our communities, particularly low-income communities and communities of color. And that's important to remember, because sometimes we'll hear from people through the hotline who may have gotten a debt collection letter, or they got court papers, and these documents that they receive are very official sounding. They can be very intimidating or scary, stress inducing, and the person may feel that or may not even know what they're about, or if they do have some semblance of an idea of what it's about, they may disagree with what's being said, but may feel that because it's so official sounding, it's so intimidating sounding, that, oh, the debt collector might, is right, and I'm just going to have to accept that. And that's simply not the case. Debt collectors are often wrong, and that is why it's so important to know your rights and know what you can do in response to debt collection when you experience it. So I'm going to start us off with the first true or false question. True or false? If I owe money, a debt collector can contact me anytime about the debt. So to take a few seconds to think about that, what does that mean? A debt collector can contact me anytime. And I'll go ahead and move us into the answer, because it's a little hard with Zoom. There's not an easy way to poll folks, but that's not true. A debt collector cannot contact you anytime to collect a debt, even if it's something that you think you might owe. Debt collectors are actually subject to many, many laws. They have to follow the law, and those laws govern what they can do. And in a lot of ways, they prohibit debt collectors from taking certain abusive or harassing actions. So, for example, we've seen through our hotline, and maybe this is something that you've experienced, or someone who's experienced this, but debt collectors, we've heard, may call people incessantly. It's just nonstop, it's overwhelming, it's stressful, and they're not allowed to do that. There are, in New York City, there are limits on how many times a debt collector can reach out to you. They're not allowed to contact you at very inconvenient times of day, super late at night, or obnoxiously early in the morning. And we've heard that as well, people being overwhelmed by these just incredibly intrusive debt collection calls. Debt collectors are not allowed to talk to people about the debt. Maybe they're calling your family members or your workplace and talking about the debt with those people in your life, and it's incredibly intrusive and invasive, and they're not allowed to do that under the law. So those are just some examples of the abusive actions that debt collectors are not allowed to take. And unfortunately, we do see that they still happen. And that brings me to the second point on this slide, which is why it's so important to know what your rights are and that there are these protections, because you can assert your rights and fight back against some of this incredibly abusive, harassing, and invasive activity. So one main thing that when we speak to our hotline callers about how to address abusive debt collection, one tool that you have is the right to, for example, ask that they stop contacting you. You can write a letter to a debt collector and say, stop, I don't want to hear from you anymore. And that can be very helpful, because debt collection activity is really stressful and overwhelming, especially if they're engaging in this problematic activity, nonstop calls, really inconvenient times of day. And sending that kind of letter to ask that they stop contacting you won't get rid of the debt, but it at least can provide some relief from some of that abusive behavior. Another tool under the law and a right that you have is you can send a letter to the debt collector that's called a verification letter, or a dispute letter, sometimes it's called. And what that letter does is it tells the debt collector that you disagree with what they're claiming for one reason or another. One example may be that they're claiming an amount that you disagree with. Maybe they've tacked on lots of interest, or maybe they've tacked on lots of fees, or maybe you don't recognize the debt at all, but there may be grounds to dispute the debt and request that they prove what they're claiming, essentially. And when you send that dispute letter to the debt collector, under the law, they have to stop all debt collection activity until they respond to you and provide that evidence that or proof that they're required to provide. So that's also an incredibly helpful tool because it prevents them from continuing any kind of debt collection activity. And, you know, we've talked about calls and letters, so it could include that kind of activity, but it also includes a whole other category of debt collection that I'm going to talk about next, and that is debt collection that has moved into the courts, when debt collectors try to seek to get your money by filing a lawsuit against you. So that brings me to next, true or false. True or false, a debt collector can take my Social Security and my unemployment insurance. So thinking about this question, if you think you owe a debt, or if a debt collector has been hounding you and you have something like Social Security or you're receiving unemployment, you may be under the impression that they can get that you have to give that up to them. In actuality, the answer is no. Under New York law, many types of income are protected from private debt collection. A lot of government benefits are included in that. So if you think about Social Security, public assistance, workers' compensation, pensions are protected, federal student loans, a whole number of categories of income are protected from private debt collection. And there are other protections for other types of income. I'm going to jump back to that in a little bit, but first I want to talk about this piece of debt collection. This is the second big category of debt collection that we hear about through the hotline. And again, you know, we're hopeful that this may be helpful to you and maybe resonates with something you've experienced. But I mean, we don't hope that, but we're hopeful that this information can be helpful to you. After debt collection calls or letters, the next stage that we hear the most about is lawsuits. So someone that we've spoken with may have received court papers that could be in the mail, or maybe they were handed to them, and want advice on what next steps to take. So generally, when this happens, very important to seek legal advice. You know, again, depending on you may recognize the debt, or you may have some long background where you think, oh, they've got me now because they've sued me. But it's really important to seek legal advice, because a lot of the time we speak to people who have legal defenses in their case and they just don't know. And so it's important to get advice and to make sure that you're being advised on the full picture, and that you know your defenses and you know your rights in the lawsuit. It's also very important to react quickly. With debt collection, as I said at the top, you have rights at all of these stages. Some of those rights are time sensitive, and if you don't assert them in the right time, you may lose them. So with debt collection calls and letters, that applies, and the same applies with lawsuits. Definitely, there are deadlines that you need to be aware of, and you know, we often hear from people who are receiving lots of mail. Maybe they got court papers, but it was incredibly stressful. It was incredibly overwhelming, and they didn't know what to do. And that's very understandable, but it's very important to react quickly, because there are these deadlines, and you want to make sure that you're not missing any key deadlines in the case. Another key thing to do in a lawsuit is to continue defending yourself. If you're getting court dates, make sure you go to court dates. That it sounds obvious, but it's a very important way to make sure that you continue defending yourself in a lawsuit and making sure that you're asserting all of your rights in time before it's too late. So then that brings me to the third piece of debt collection that we hear a lot about, and that is towards the end of the lawsuit. So we hear from people at the beginning of a lawsuit, and we also hear from people at the end of a lawsuit. If a debt collector or a creditor has filed a lawsuit and then they win the case, that essentially means that they have gotten court power to try to collect money from you for this debt. And what we often see we often see people discovering that this has happened for the first time if they've learned that their bank account is frozen, or they've learned that their wages are going to be garnished. They may have gotten a letter from the city marshal saying your wages are going to be garnished. Maybe their employer told them that they're going to start garnishing their wages. And with this stage of debt collection also, you have rights, there are avenues that you can take to try to address what has happened in court, so that you can address what's happening with your bank account or with what might happen with your wages. And that's where these laws about what's protected from debt collection are a hugely important piece of information, because if your bank account is frozen, but it contains these kinds of exempt income, then it can't be frozen. And there are steps that you can take to make sure that you get that money back. New York law also protects minimum balances of bank accounts. So if your account contains government benefits, you're automatically entitled, even if there's a freeze on your account, to $3,000. If it contains no government benefits, you're automatically entitled to $3,600. There are similar protections in place for wages. If you earn a certain amount per week, if it's under a certain amount, you can't be garnished at all. If it's over that amount, you can only be garnished a certain amount. So there are, New York has very strong laws protecting this type of income. And it's helpful to know that, because if you are experiencing something like wage garnishment or a frozen bank account, you have these protections in place, and you can do what you need to do to make sure that you're getting what you're entitled to under the law. So that brings me to the last piece that I wanted to address that relates to debt collection, and that is credit reporting and how debt collection activity may impact your credit report. So starting again with a true or false, true or false, I can correct inaccurate information on my credit reports. So first, what are credit reports, and why does this kind of question matter? You all may be familiar with the three big credit reporting agencies that collect information about your credit activities and then report it in these reports. They're private company, TransUnion, Experian, and Equifax, generate these reports. And I think one key thing to remember when you're thinking about your credit report is that these reports are notoriously filled with inaccuracies. Sometimes the inaccuracy is not a big deal. Maybe it's just some personal information, address, contact information that's not up to date. But sometimes what is inaccurate is a big deal, and it can have a big impact on you. And that's why it's so important. Moving to the question, you can correct inaccuracies on your credit report. There are laws protecting your rights in this area, and there are steps that you can take if your credit report contains inaccurate information. There's an asterisk on this slide, and that's because while there are steps that you can take, it's not always a simple or straightforward process. Sometimes the inaccuracies are debatable. They're the kind of inaccuracies that are in the eye of the beholder. You might feel you might say and put forward documentation to explain why something on your credit report is inaccurate, but there may be lots of back and forth where the creditor disagrees, and it can be very document heavy process, and it can be challenging and not always straightforward to make these challenges to inaccuracies on your credit report. But it's important to remember that you can do this, and we're always happy through the hotline to talk with people about what they're seeing on your credit report that is inaccurate, and ways that means that you have to try to challenge those inaccuracies. I wanted to add with credit reporting, employment credit checks. New York, if you're seeking work or you're an employee now, New York City law is the strongest in the country, and it prohibits employers from checking your credit in a large number of categories of jobs: restaurant workers, bank tellers. There are lots of different categories of jobs that the law applies to, but it's one of the strongest in the country, and it prohibits employers from looking at your credit to make decisions about your employment. So that's also a very important, it's such an important aspect of what anybody does, and so it's a really valuable law to keep in mind. There are, of course, ways to try to improve your credit beyond, of course, disputing inaccurate information on your credit report. You can try to get positive information added to your credit report if it's not already there. And you can try to build credit by, for example, taking out a secured loan with a trusted source. And so those are some of the main areas of debt collection and credit that we wanted to talk about. But speaking of sources and resources, just wanted to reiterate that New York City has lots of resources available to people when it comes to questions about, if you have questions about managing debt, you want to speak to a financial counselor, or if you have questions about financial justice issues, we are at the hotline are happy to talk with people. If you've experienced anything like that sounds like what I've talked about today. There are also New York City provides free financial counseling. If you call 311 or visit nyc.gov/talkmoney, they provide free financial counseling through financial empowerment centers. And you also might look into services provided by community credit unions, which are credit unions or financial institutions that serve the community. And many of them provide financial counseling services as well. One of those, as an example, is Neighborhood Trust. So those are just some resources we wanted to highlight, and we're happy to answer questions now as well. And I'll hand it back, I think, to Senator Krueger.
Very much, Raquel and Sarah, and I hope that Ellen will turn her photo back on, because we're going to get to as many of these questions as we can. And maybe I'll start with housing questions just to give our two debt management experts a moment to take their breath. So on housing, Ellen, is the amount of money that I could possibly get through the rent relief program going to just pay back rent I might owe, or will it also be ongoing for rent?
The program allows for 12 months of back rent and 3 months of rent in the future. But you can only qualify for that if you can show that you pay more than 30% of your income towards your rent, that you are currently rent burdened. And it's not, it's any 12 months. So if you were able to pay your rent through September, and so what you owe is from last September, it may make sense to think about when you apply for the rent arrears, because you can get, as I said, up to 12 months back. And then you can buy yourself some more time with the rent going forward. But it's true, the rent relief program is backward looking. It's trying to clear up rent debt. It doesn't address the issue of a huge number of people right now who lost income and can no longer pay their rent. The things I would think about and look out for is there are going to be additional Section 8 vouchers coming to New York. We should know soon how many vouchers are coming and to which agency, which HPD or NYCHA, and they're going to have to come up with rules on how people apply. And we are also in the infrastructure bill that the federal government is talking about. There's been a lot of push to consider housing and housing instability as part of infrastructure. And so we're looking to see even more vouchers maybe come from that, so that people can get subsidies so that they can be more stably housed, because that's better for all of us.
Right. So I understand that when I apply for this emergency rent or back rent relief, that I have to submit financial details with the application, but I don't really want my landlord to see my financial details. Is there anything that can be done to assure that he or she doesn't have access to my financial information?
The application is through a third-party vendor that works with the state agency, and there are confidentiality rules that will not allow them to share information with your landlord. But your landlord will have some basic information about you, based on whether you were found eligible or ineligible. Right? If you apply and are found ineligible, it may, your landlord may suspect that your income is over 80% of area median income. Of course, it could also be you didn't receive the money because you didn't lose income. But that's the only information that the landlord would be able to glean. And certainly, some landlords want to apply jointly with their tenants. In order to do that, I think those tenants will have to work with their landlord and provide them with income information, but you don't have to apply jointly with your landlord. You can apply individually.
And if you're trying to reach out to your landlord so that you can get certain information that will help you file, but they don't respond to your calls or requests for help, do you need them in order to file for this money?
No, you do not need your landlord to file for this money. However, the money goes to your landlord. And so in order for the agency to pay your landlord will have to cooperate with the agency. There's not a lot that the landlord has to do, but absolutely the landlord will have to give taxpayer ID information, his taxpayer ID information, to the agency. The law that was passed, and this is why it's so important to have legislatures who look out for tenants, has a bunch of measures that protect tenants who landlords don't cooperate, which is that if your landlord refuses to cooperate, you are eligible for the program, you will get a letter. And that letter will say, you are eligible for the program. We want to pay this amount of money. The money will be set aside for a period of time. If during the first year after you receive the letter, the landlord sues you for the money, either in a debt collection type of case or in housing court, you can use that letter as a defense. The fact that the landlord has refused to take money from the state is also seen as discrimination based on source of income. So we think that within that first year, if tenants are sued for the money and they bring the letter to the court, we expect that judges will look at the landlord and say, well, they wanted to pay you. Why wouldn't you take the money?
Right.
Now, we have some worries. What happens after 12 months? People forget. If a landlord waits more than 12 months to then go seek the money, the statute says that the money is waived. The landlord cannot seek that money after 12 months. So to the extent your landlord doesn't cooperate and you get the letter, I would make as many copies of the letter as possible. There will also be databases, and it should be relatively easy, we believe, to get access to the information that you've been found eligible, and you will be able to use that in court to defend against your landlord. The law really encourages landlords to cooperate if they want their money.
So last question for you, but it's a little complex, but I totally understand it. So it was pre-COVID. I was in a harassment fight with my landlord. He had been harassing me to get me out of my rent-regulated building. So I hadn't been paying him rent, and there was a court case. But then suddenly COVID happened and I lost my job and I really couldn't pay rent. So I assume I'm going to apply to try to get money for the back rent, but I really only want him to get the money he would be entitled to separate from the harassment problems. But I don't want him to figure out that maybe he can just try to get me out of the building on somehow, because, somehow the harassment stuff blends in with the lost all my income and job in COVID. Is there something special I should be doing to protect myself while making sure he doesn't get the money I don't believe he should be owed from previous times and harassment?
It's a little hard to parse that out. I want to say, I think, so my recommendation is, if you think the money your landlord says is owed is not the money that is owed, then what may make sense is for you to resolve this through a housing court case, because all tenants in housing court cases are currently being represented by counsel. In fact, there used to be income restrictions on people getting counsel. That those restrictions have been lifted, but again, if you qualify for COVID relief and you're under 80% of area median income, you will qualify for the right to counsel program. And so it may be that it would be helpful to you to figure this out in the context of a court case, so that your lawyer can make sure that the amount of money that your landlord actually owes is what he receives. Having said that, while there's a warranty of habitability, and if your landlord doesn't do repairs, you may have a discount and not pay 100% of your rent based on what the repairs are. I haven't seen a lot of discounts for harassment activities. But this may be the perfect moment to do that.
Okay.
And as for, just one more thing, for worrying that after your landlord gets the money that you get evicted. Now, if you're a rent stabilized tenant, remember that it is very hard to deregulate apartments these days after the legislature passed the Housing Stability and Tenant Protection Act. But let's say you're an unregulated tenant. Some tenants are worried that my lease is up and my landlord's going to take the money, and then he's going to say, I'm not renewing your lease, and get out. When the landlord takes the money, he cannot bring what's called a no defense holdover, your lease is up and get out type of case for a year. And so it will allow people to remain in their home for a pretty good period of time.
Right. So that is the extra protections. Thank you. Thank you, Ellen. All right. Now we're shifting to other kinds of debt. So New Economy Project. I've heard what you said. So I don't really love the idea of trying to go for bankruptcy, but I also really don't want my bank accounts and other monies seized and go through multiple lawsuits. So how do I make that decision about whether bankruptcy is the right answer for me? And I also heard that the federal government might be changing the rules of bankruptcy. And should I be aware of that and think it through in the context of how the rules might change?
Sarah, do you want to?
Raquel, why don't you start and I'll do this, I'll answer the second part.
Okay. Well, so I'll start off by saying just that we at New Economy Project don't do a ton of work on bankruptcy specifically. So in weighing that kind of decision, we would advise to speak to a bankruptcy attorney for the specific elements of, the bankruptcy side of things. When it comes to the underlying debt, what is amounting to the reason that bankruptcy might be an option. We are always on the hotline, happy to advise about what your rights might be in specific cases, understanding that all of that can be very stressful to navigate and a lot. But it's hard to advise on now without more particulars. But that's why we would encourage you to contact the hotline, and with the bankruptcy piece, to speak to a bankruptcy lawyer as well.
Okay.
So
And
yeah,
so-
the second part about changes at the federal level, it does feel like a million years ago this happened, and in some ways it feels like yesterday. But in 2005, Congress did what they called bankruptcy reform, and what it really was a bill that was written by the credit card industry and their friends, and that made it much harder for people to file for bankruptcy, and really was very, I'll call it anti-American, but really against the people. And so there is now an effort, as you pointed out, to really change that. And Elizabeth Warren and other people, she wrote for many years as a law professor about the harms of the bankruptcy reform of the mid-2000s. That was kind of her area of focus as a scholar, and how this harmed women and others, women in particular, but just the damage that did. So there is an effort. I don't know if it will pass. It's hard to say. So to kind of make your personal decision based on possible restructuring, I mean, she and others are calling for an absolute revamping of the country's bankruptcy laws, which is due and needed. But we'll see. It's hard to know, when and if. So, as Raquel said, we don't do bankruptcy law. And as I said at the beginning, we don't do debt, sort of debt counseling, but without knowing more about a person's personal information, it's very hard to advise legally or on bankruptcy. So we would suggest that people who are watching tonight and listening tonight, that and in watching the video later, please don't hesitate to call our hotline, because there we can talk to you one-on-one about your own personal situation and give you referrals to free bankruptcy lawyers that are good, and give you a sense of that. But I wouldn't wait for those changes at the federal level if you are in a very dire situation right now.
Thank you. Okay, credit cards. So my credit card company continues to charge nearly 19% interest on my balances, even though I've been making my minimum payments on time. Also, the bank, which is, they say Bank of America, has continued to charge interest on a closed account, even though I was making timely minimum payments. Is there any recourse for me? That these interest rates are so high, even during the pandemic, and they don't seem to be willing to do anything.
Yeah, I mean, we hear about this kind of thing a lot. And I think sometimes people feel like, but they're my bank. That's where I've banked for years. Shouldn't they be nicer to me? Don't they owe me some kind of, decency and dignity? But that's not how it works. And these credit card companies, the national banks in particular, they charge a lot. And here's something that I think Senator Krueger can attest to very directly, which is that right now, there is no limit on what national banks can charge on credit. There's no what's called a usury limit. And people have fought for it in Congress, a few people, to actually cap the interest rates for credit card companies that are national banks. And the national banks really dominate the credit card industry. So what state legislators can do is very limited, because there's the way that our banking law is set up is that states can't regulate national banks on many, many, many things. So now in New York State, we have an amazing interest rate limit. It's actually, it is a crime in New York to charge more than 25%. It's our criminal usury law, and we'd like to keep it that way because it's something that actually serves to keep payday lending out of our state and other really predatory forms of lending that in states that don't have usury caps have really created tremendous suffering and exploitation and financial distress for people. So we have really strong protections in the state level, but there is nothing legally that are wonderful, like someone as amazing as Senator Krueger, there's nothing she can do to get any kind of authority legally over these national banks. So I don't know what to say except that you can, believe it or not, this is like one of these things of like just audacity. Some people call up their credit card company, and we have heard from lots of people, if you call and you say, you need to lower my rate, there's a pandemic, this is outrageous, 19%, come on already. Sometimes that's successful, but that feels very weak to be able to, just sort of suggest or advise that what you need to do is call them and try to negotiate. It has helped for some people, but what we really need to do is change this whole scenario, because it is incredibly exploitative and extractive, and billions and billions and billions and billions of dollars are being made off of this extremely high interest. Something, I said our criminal usury law is 25% in New York State. It's our civil usury law, it's not a crime, but it violates our law to charge more than 16%. So that 19% that you're talking about would actually violate New York law if New York law could have authority over these national banks. So it's a pretty weird part of our law that the national banks have made sure stays that way.
Okay. So next one. I have a Chase credit card with a pretty hefty amount on it, and I received multiple offers to settle with Chase. Their offer started at $3,000 last summer. Then they said they would take $5,000 in the fall, and recently they offered me that they would take $8,000. I've not responded to any of their proposals. One, why does it keep getting bigger that it would take, $8,000 to pay it off instead of $3,000 to pay it off? And two, can they see my actual bank accounts at Chase? Because maybe it's all correlated to how much money they actually know I have in my bank accounts. Like, I didn't know anybody was allowed to do these kinds of things.
Let's do a tag team, Raquel, you start.
Sure, I'll start. So in terms of what they're offering and when to get back to them and how to get back to them, a decision to settle or come to a payment agreement is always personal. It depends on your circumstances. It depends on what you can afford. We generally would advise people, of course, not to agree to anything they cannot afford. And so, that process of negotiating is something that may be helpful to get financial counseling on, to just sort of assess what you can afford and what your expenses are, and proceed that way. What we've seen through, the way debt moves, when it goes to calls and letters, and when it might go to a lawsuit, there may be various stages. Of course, it depends on any particular case, but there may be various points at which you can try to approach negotiating with more information, depending on how things pan out. So it's always a very personal decision, and it depends on your circumstances. And so the resources for helping with financial counseling and looking at your expenses and what you can afford can be very helpful for making that kind of decision.
Got it.
And on the second part of the question, do you mind if I
Yeah.
take a second on that one about whether they can share information about you among different divisions within the bank?
Yeah.
So, I mean, we're a financial justice organization. So, you might not be surprised for us to say that, it's a really rigged, messed up system where, the laws that the banks have gotten passed include ones where the burden is on us to tell banks, you may not share my information. So banks are allowed to sell information to other financial institutions about all of us unless we take action to opt out. So, you sometimes get these things in the mail saying, privacy notice, and then it's this, tiny print about how you have a right to opt out. And they tell you, these are the entities that we share your information with. But there's this, not only is the burden on us to opt out, but you may not, under the law, opt out of a bank selling or sharing within its own corporate entity information about you. So yeah, you have your checking account, you have your credit card, maybe they own some other entities. If you look at Chase, I think that was the example that your questioner gave, Senator.
Yes.
If you did a corporate chart for Chase, it would go on for pages and pages and pages, right? So
Right.
they can share that information internally, and there ain't nothing any of us can do about it by law. And this was considered financial modernization. And so they used our information to sell us products. And they sell that information unless we take the step of opting out. And the sale of you can only opt out again out of information sold outside of that corporate entity. So sound like a fair deal? But the questioner should understand, yeah, you're right to have that concern.
Right. Okay, so I've been trying to be really good, paying down my debt. Why is my FICO score going down instead of up?
So FICO scores, credit scores, people we get a lot of questions about credit scores. Credit scores are a number that these credit reporting agencies that Raquel was talking about, that they derive through a secret formula. We don't know how exactly because it's not public. So they generate this number based on this information in our credit reports. We don't ask for credit reports to be gathered on us. These are private corporations that are amassing huge amounts of data and then selling it. So we don't ask for it. There are all these errors. There's this number generated. We don't know exactly how the number is generated. And then that number dictates our, cost of a mortgage and all sorts of other things. So please call our hotline if you want to talk about your rights under the Fair Credit Reporting Act. But it's, if you're paying off a debt, oftentimes that means your credit score is going to then go up. But there's this whole thing in the formula. They'll tell us the categories that go into the formula, but not the exact numbers. There's a category around how long you've had your debts. And if you have debts for a long time and you've been paying them off, that helps your credit score go up. So if you close a lot of your debts and your credit cards and so forth, that can affect your credit. I'm not saying that's what's happening to the questioner, because I need more information to answer that definitively. But there is this kind of crazy thing where the longer you have the credit, the higher your credit score. So there's this bias towards carrying credit rather than being credit free in the credit scoring model.
Got it. Well, I have a half hour more of questions, but we promised that we were actually going to be done now. So I want to apologize for people whose questions didn't get answered, but remember, and they were, I think, mostly for Sarah and Raquel, they have a hotline. You can call and talk to them. I want to thank Sarah Ludwig, Raquel Villagra from the New Economy Project. I want to thank Ellen Davidson from Legal Aid Society. I want to remind everybody that our next virtual town hall will be with the Manhattan Chamber of Commerce, and we will be covering small business recovery resources at the local, state, and federal levels. That will be Thursday, May 13th, starting at 7 p.m. And I'm going to have my colleague, State Senator Anna Kaplan, the chair of the New York Senate Commerce, Economic Development, and Small Business Committee, and Jessica Walker, President, CEO of the Manhattan Chamber of Commerce. Again, I just want to thank all the guests here tonight, and for all you who listened in, remember, get vaccinated. Tell everyone get vaccinated. Herd immunity should be our favorite word. Now we've all done it ourselves. We're going to go out there and make sure that New York has herd immunity, because we're going to get everybody vaccinated. Okay, and keep your social distance in public spaces and just be smart and safe. Thank you. Good night.